Now, we are going to hear 235 Elm Street. Giri Dedham LLC, the Inn at Dedham, request for a permission to resubmit an application for a special permit catering use at 235 Elm Street in Dedham, Mass., previously denied by the Board of Appeals pursuant to its decision of February 21st, 2024. Plus or minus 3.9 acre subject property is located at 235 Elm Street in Dedham, map and lot 162/7, and is located within a research, office, and development zoning district. Who is here representing the applicant?
Good evening, Michael Van Dam for the applicant.
Hello, Michael.
Nice to see you.
You too. Okay, so this is a tricky one. I don't think we've ever done this before, Jeremy.
No.
Had someone come back under this language. So before you get started, I know there's a lot of people here in the audience that want to speak on this application. So I want to try and explain what it is. This is not the hearing that we had in February. This is whether or not for us to decide whether they get an opportunity to have another hearing. Okay? So he is going to present material changes to our previous application that would justify us allowing him to come back before us again. Is that correct? Does everybody understand that? So we are going to open it up to the public because that's consistent with what the Zoning Board of Appeals always does. But I want to make sure that we are all respectful of the process, respectful of each other. When last time people got up at the microphone, there was a little back and forth from the microphone to the audience. Do not do that. Direct your questions through me, through the chair, and do not interact with each other. Keep it professional. And I'm not going to have people getting up saying the same thing over and over and over and over again. If a couple people have the same message, we'll hear it, and then we'll move on. Okay? So just be respectful of each other, be respectful of the process, and everything will be fine. So, that being said.
Thank you, Mr. Chairperson. I think you said it correctly. This hearing is what is often called by judges where I practice, called a gateway matter, a threshold matter, whether the applicant can reapply based on Section 40A, Chapter 40A, Section 16. And the section is a bit obscure, to be candid. I've never dealt with this issue myself, as you mentioned, you haven't. But I did, read the section and did some case law research, as I think I'm obligated to do as an attorney. And the section, specifically as you stated, needs a specific and material change in the condition upon which a previous unfavorable action was based. And there's no legislative history in these types of laws like there is, in some other federal or other issues. But I would gather that the intent of that is applicants don't try to have a second bite at the apple when they shouldn't get the second bite at the apple under the same facts. Maybe there's a new board, or maybe a board member's sick, and they, want to take that second bite at the apple to get something that was already declined based on what we call, or what you call, collateral estoppel. So I think that's why the law is enacted. I think it was in the 1960s. So in that backdrop, and thinking about that, this board needs to decide if there is a specific and material change in conditions upon which the previous unfavorable action was based. And when you read the decision by this board, it's very thorough. And basically what it says is that the applicant should have a tail between its legs because it didn't do a good job presenting material facts to this board to make an educated decision whether this board should deny or allow it. It didn't much get into the substance of, well, there's too many of this or there's not enough of that. It basically said, you didn't give us enough information and we can't make that decision. And maybe because the applicant didn't have a lawyer or didn't pull it back with prejudice, as you suggested to the previous applicant in the last hearing. So here we are. I'd say that Plenty of people don't like hiring attorneys, including myself, and at the last case, they didn't, and I think that they should have, because they would have done that maybe first bite at the apple and giving you substantive information that could allow this board to make its decision on those substantive facts. So having said that, I did attach a proposed, on our second go-around, which I'm sorry these people have to come twice, what we are going to present to the board, but we're here for this gateway or threshold matter, and I'd suggest that we have now there is a change, that the unfavorable action was based on not enough information, and I can make an offer of proof that we're presenting, when we go ahead, enough information, substantive information for this board. So for those reasons, I think we have satisfied Chapter 40A, Section 16, and we'd ask for that second bite at the apple. Thank you.
Okay, thank you. Members of the board, questions for the applicant? Tom?
So I read your letter requesting the hearing, and we did get some advice from legal counsel that cited Rainey versus Board of Appeals of Nantucket, which seems to be the central case on the matter. So I just want to make sure we state everything thoroughly and clearly. Section 16, the statute basically reads as this, but I basically converted it to the language that would be needed this evening. So Section 16 of 48 reads, "No application which has been unfavorably acted upon by the ZBA shall be acted favorably upon within 2 years after the date of the final unfavorable action, unless the ZBA, by a vote of at least 4 of its 5 members, finds, 1, specific and material changes in the conditions upon which the previous unfavorable action was based, and 2, describes such changes in the record of its proceedings." So we have to make that finding, and we have to describe it into the record, and then it gets transcribed into the decision or the minutes of the meeting. So those 2 things have to happen under the statute. And in addition, you would be going before the planning board, where I believe, unless all but one of the members of the planning board consents upon you moving forward. So there's like a 2-board process to this, okay? So the findings the ZBA must make are as follows. Have conditions in the application for the special permit sufficiently changed to allow the ZBA to consider a second such application within the 2-year period prescribed by Mass General Law, Chapter 48, Section 16. So that leaves basically 2 questions. Are the modifications or changes proposed by the applicant a specific and material change in circumstances? And are the proposed modifications responsive to a ground for refusal mentioned in the findings by the ZBA in rejecting the first application? So those are the questions that have to be answered and addressed. I would state the policy which underlies Section 16 is to give finality to administrative proceedings and spare affected property owners from having to repeatedly go to the barricades on the same issue. That is what the judge said in the Rainey case, okay? It then goes on in the decision to say, at the same time, the statute provides the ZBA with some flexibility when the circumstances have changed. The Rainey case involved a hotel changing the lighting or the recessed lighting changing the room darkening drapes, installing soundproofing, and installing a hedge along the property line, all in response to the concerns raised by the hotel's neighbors in the hearing on that first application, okay? So the court ruled that the proposed changes were directly responsive to the board's initial objections and were specific and material within the meaning of the statute, okay? So I've heard what you had to say, and basically what I understand you saying is that, in your letter, was that basically the representatives from Giri at the first meeting didn't do a good job explaining the facts, and that council may be able to articulate the argument better. So that's basically what you stated in the letter. You stated that your letter dated June 25th, 2024. You stated that Giri failed to provide necessary information at the first hearing, basically because they failed to have an attorney present to advocate on their behalf. So as a result, the ZBA's decision was based on Gary's failure to provide needed information rather than a substantive decision related to the underlying circumstances. So that's basically what I read in your letter and what I saw in the case law. But my question to you is the failure to provide additional information through counsel a substantive and material change in circumstances under the statute? I read the brief accompanying the second application, and Giri is asking for the ability to provide 3,000 meals per day, the same amount requested in the minutes for the hearing for the first application, which I read through, okay? Giri is asking to maintain the hours of operation from 5 a.m. to 11 a.m. in that brief. That's the same period reflected in the minutes of the hearing for the first application. Giri plans on 3 food deliveries per week, the same delivery schedule reflected in the minutes of the hearing on the first application. And you are stating that food waste will be disposed of in a dumpster, where I would tell you the minutes from the first meeting or the first hearing reflected that there would be 2 dumpsters. So we're actually going down in dumpsters. So you got to tell me.
Sure.
Why is having an attorney a material change in circumstances when essentially your underlying brief for the second application is requesting the exact same relief as the first hearing?
Very well. Those are good questions, and I'm almost 50 years old, so it was a long time ago that I went to law school now, and all these issues that you bring up are law school exam issues in the sense that I have also gone over that case that you referenced, and I've gone over, I brought with me today another case, Penn v. Town of Barnstable, because I want it a little fresher. This was 2019. Every case out there really goes into what you're saying, that they deny it based, or they allow it based on the substance, like you're saying, that case. You know, it's the neighbors say it's too loud, so the applicant comes back and says, we put soundproofing. So now, you know, there's a change. There wasn't soundproofing, now there is soundproofing. And every case that I studied today went into the substance. So I couldn't find a case on point that says if your argument is you didn't provide enough information, and I know you disagree with that, you know, we think I'm still apples to apples, and I'll get into that in a second, but if you don't provide enough information, you know, no court that I found searching since 1960 something was on point. And that's the story of my life, I guess, in terms of I could never find anything on point. So what I brought up at the beginning of my remarks is into the law school, if you don't have something on point, you have to look at the legislative intent. And I did read that sentence that you quoted about having the public come back and things of that nature. But I would say, and I would argue that if you think about the intent, and you have to go with your own thought process because there is no legislative history, it's, as I started at the beginning of the remarks, I would argue that this also covers when it's honed in on that the board made its reasoning, and I'll read that in a second, that there wasn't enough substance. So I would say that if you think about the intent and the applicant trying to move the goalposts where it's a new board or it's someone's not there or something like that, and gamesmanship, it's trying to prevent, in my view, gamesmanship. The fact that the applicant or the client was negligent or just, didn't do its homework correctly, I don't think the intent of the statute is trying to prevent that person or that applicant to get the second biting to the apple. Now, in terms of your second question, in terms of when I read the statute and it says material change in conditions upon which the previous unfavorable action is based. And the case that I brought today, Penn v. the Town of Barnstable, the judge cites that sentence. And you think about, I'm sure this board uses the word narrow, no, I know it does, narrowly tailored, the zoning or the what have you. And when I read the reasoning of this board, it says, as reason for the decision of the board to determine that the applicant had failed to provide sufficient evidence of impact of the proposed new catering use and the town, in particular, the applicant failed to provide sufficient evidence on how the operation would be conducted at the site, the frequency and magnitude of delivery of operations, the parking, and the loading requirements. So I know what you read a few minutes ago, but when I read the written findings of this board, it basically says that, like in your example before, we can't even understand the decibels of the restaurant in Nantucket. You didn't tell us the decibels. You didn't tell us those 5 things. And we need you to tell us those 5 things. So I respectfully disagree that this board, in its reasoning, which it's bolded reasoning of the board, is that you didn't tell us these things. So the fact that we wrote, yeah, this dumpster, that, I think that the presentation that we'll make at the next hearing will give, and the people that are here, will give those issues, those 5 or 6 issues, more substance that wasn't brought in the written application at the comments made at the last hearing. So if you take that coupled with what I argue is the intent of this statute to provide, to dissuade applicants just trying to get another bite at the apple on the substantive, hey, this thing still doesn't have decibels, soundproofing, but hello, there's a new board and maybe they won't mind. So I think if you couple those things, I guess this board will be making new law. Okay, because there's nothing that I found, and I think your counsel found, exactly on the point, which is the applicant bungles the application by not giving the community enough information. They bungled it, but they should get a second bite, not that they're trying to just rehash the same collateral issues. So, thank you.
I appreciate your argument, and I think it's well constructed. Is there anything you can tell me about the changes in the presentation? Not to debate and argue, but just, is anything changing in the basic application the second time around?
Well, I want to reserve my rights because I was so preparing for this threshold hearing. But I think there will be, and I think that now it's, this dumpster issue, for example, we'll bring in another dumpster if that was what was in there. It's unfair and it's unethical of me to just look you in the eye and tell you there will be major changes because just to get through this. But there is we were preparing for this first hearing to suggest and argue why we satisfied Section 16.
I would just, see, I think the case law basically talks about not so much giving the applicant flexibility, but giving the zoning board flexibility. So if they make a decision and it looks like it can be changed to accommodate the parties, you have the ability to reopen it. But you also have to weigh that against the basic principle of finality. That if you set a precedent and you say, come on up by yourself, like the prior woman this evening, and if it doesn't work out for you, appeal under Section 16 and say, I'm going to bring in an attorney next time to make you understand what I'm trying to do, okay? So every time someone comes up pro se, we get a letter 6 months later saying, I need a redo with an attorney because I didn't get the job done the first time. So am I sitting on a board that basically should book double hearings on every single zoning relief matter? Because I know that if the first time doesn't go well, I have to hear it again with an attorney? Or to compound that, you hire some schlep attorney and he does an awful job. Do you come back 6 months later with Wimborne, Hampy, and Sheehan? Hello, Mr., it's just making a, Mr. Hampy.
I know him.
But do I so now do I bring in a better attorney the second time
Right.
around and say,
Right.
I need a rehearing because my first attorney was lousy, so now I got a gun? So it's kind of like,
You're making,
I
yeah,
vote in the prior hearing,
yeah.
I was one of the votes to grant relief, okay? But tonight, it's not about the underlying merits. It's really a question of policy and law. And I don't think you have it under the law. I think the law doesn't provide under 48 Section 16 the theory that an ineffective presentation is a sufficient change in circumstances to warrant a second hearing. So that's just my opinion. I've taken up most of the board's time, a lot of the board's time. If you want to respond, you're free to, or the other people have questions as well.
Did you want to respond?
Sure, I'll quickly respond. I understand you're making the classic slippery slope argument, right? You open the floodgates, and now everyone's going to say, I didn't hire an attorney, or my attorney didn't do a good job, I want a second bite at the apple. I certainly understand that, but I think that if this board is tasked, and I respectfully disagree, looking at the four corners of this section, and there is no case law on this exact thing, so we're all going to become famous maybe, that under this statute, if you tie in, and maybe the board changes the way they write it later, if you tie in the material changes and the conditions, so you could go to the United States Supreme Court on the definition of what is conditions, right? Does that mean that they're soundproofing? Does that mean the condition is, when I look at the reasoning of the board in your findings, that they bungled it? And now we're going to not. So I understand the slippery slope argument, sir, and it's well-founded. But I think with this statute, and a court would look at the intent of the statute and how they come up with the intent, where there's no congressional history or something, I don't know, but they're charged to do that. I would say it's not somebody that's trying to gamesmanship and getting a second bite at the substantive apple. And you're right, it could maybe cause some people to say that they want to come twice. But the way the statute's written since the 60s, coupled with your reasoning of the board paragraph, I think the applicant does deserve this second chance.
Thank you.
Thank you.
And obviously, if you deny it on the second chance, that's it, you know.
Any other members of the board? Sure.
Would there be discussion, or I don't want to interfere with these folks that make statements, because when the board goes into discussion, I will have some comments at that time.
Okay, not at this time?
And if I may, this isn't a public hearing, so it's really just a general discourse.
Okay.
So you
Oh,
can,
I thought Scott said
I
there
will-
would be public
there
hearing.
will be,
Well, public meeting, I'm just saying this isn't, you're not closing a public hearing or anything. So there's-
Oh, okay. So I'll make my comments?
please.
This meeting, when it took, well, let me put it very bluntly so everybody knows where I'm coming from and what's happening here. I believe that the applicant should have the opportunity to reapply and to have this matter heard. The application that was heard by us wasn't even an application. It was ill-prepared and it was ill-presented. When the applicant came in with their representatives, I immediately looked to one of my cohorts here, or colleagues, and said, oh, it's going to be a short meeting because I'm certainly sure this gentleman's going to ask for a continuance so he could hire an attorney. That never happened, okay? Jason, did you get that information that I asked you to publish on the second page of the application, the original application? Could you present that, please? This is the second page of the application, the most deficient application, I think, in my short tenure here on this board that I've ever seen. It says exact relief requested. See attached. All they do was they were talking about what they wanted to do, but there was no specifics as to what they were going to do. Down at the bottom here, it says the statement of hardship. Nothing was presented, okay? So we were left in somewhat of a vacuum. That was the second large mistake that was made, a gross omission. I would say that if an applicant came in here and made an omission, and then they came back for a rehearing, I would say that it should be denied. But I have a different take on this, and I think this was a gross omission of material information, and had the board had that information presented to them, I think an outcome would have been different. We had two members of the board that looked in favor, but there wasn't sufficient votes to carry the day, so to speak. And I'm certainly sure if the correct information had been provided, that maybe other members of the board would be inclined to approve the application. The other thing that noted when I first came in here, and again, it was the inarticulate way in which this application was written and presented. I was of the opinion that the applicant wanted to reopen the kitchen for the specific purpose of providing food to the hotel next door or wherever it was. And that wasn't the case. It wasn't until Mr. Semino came up three-quarters during the presentation, and he said they already have that permission. So what basically it was to facilitate the continuation of the operation of the kitchen, which was already taking place, but to have it distributed to other places. I did listen with the passion that was presented by those people who saw a human aspect in this. The people living in conditions that you and I wouldn't live in. Children, okay, who were being deprived maybe of nutrition, whatever it is. Whether or not they came here legally or their parents did bad things, you're talking about children. So I had the compassion there in my mind. I think also that one case, and here's what my final comments, it says the submission of new information with the second application, which was not in. To me, the new information is the points that have been set forth in your brief. That's the new information. You have provided to us in your letter memorandum the new information which I believe gives this board the discretion to make a decision relative to whether or not we want to have this application reheard. Thank you.
Okay, thank you, Alan. Sarah, any comments?
I'm okay right now.
You good? Okay, we're going to open it up to the public now. So like I said earlier, be respectful of the process, be respectful of each other. Anybody in the audience wishing to speak on this application? Just give your name and address. Come up to the mic, please. Name and address for the record.
Can you reach the mic?
Jeremy will help you.
We can adjust it.
Thank you, Jeremy. Okay, my name is Carla Foley. I live at 92 Old River Place. I am not an attorney. I'm just a person who owned restaurants. I worked in restaurants for years and years, and then I went out and opened my own restaurants. Now, I would never, ever have built a restaurant without an attorney, without an architect, without the building department. I have no right to make those decisions when the public is here. Now, in my opinion, what we have here is a situation where someone who made a decision, who wants to open a business, now wants to change what they've done. And, I'm kind of tired of this in our society. When you make it, it's your responsibility. Now, why do you get a second chance? And I think this gentleman over here is right. If you do it, then every single person, and I don't believe that that this organization has the right to ask for a second thing, because they didn't hire an attorney. If they had hired an attorney who presented all of the information in the beginning, I'd say fine. But I'm opposed to this. And I think it was not done right. And for someone who's supposed to be a huge restaurant operator or whatever, they certainly don't know the rules when you don't go before this board. Thank you.
Thank you, Carla. Other members of the audience? Young lady?
Hi, Jane Donegan, 8 Rosen Road. I initially thought that this was a meeting, that this was the second chance meeting. Just from listening to you speak about why you think Giri deserves a second chance, it makes zero sense at all. It seems like they, didn't fill out the application properly. The guy who owns Giri is either a millionaire or billionaire, and he can afford lawyers, so it seems like he just threw it together thinking, hey, it's state money, we'll just write this out, and then he thought it was a done deal. So when people opposed it, now he's gonna come back, I want a second chance. This is taxpayer money. All of us we pay so much taxes in the town for the state. This is all state funded, and I did a lot of research on it. First of all, I have also the compassion for the children and the people that are living in the hotel. However, what I've found out in my research is Giri, or Giri, however you say it, is charging $54 a month for a hotel room with 2 beds and a bathroom, no kitchen. I've looked up, I did research, fair market value for rent of a 3-bedroom apartment in Dedham is $35.88 per month. A 4-bedroom is $39.53 a month. They're charging $5,400, per month for a hotel room. And it's taxpayer money, so that's my money that's taken out of my paycheck, my husband's, all of these people here. It's abuse of the system is what it is, and that's what I'm disturbed about. I absolutely would love to help people. I think it can be done at a lower price. Also, I don't know if anyone's seen it, but CBS News in Boston did an expose about the food that's being served, that's right now by Giri, and they specifically did the expose on the Fairfield Inn in Dedham. If anybody wants the link to it, I have it on my phone, I can share it in a video. Specifically Fairfield Inn in Dedham, the food that they showed that they were serving the people was plain spaghetti with a hot dog thrown in there, very cheap, that's very inexpensive food, and they're charging anywhere from two different things I've seen. One was $68 per person per day, and the second one I saw was $37 per person per day. So if you average that out times 7 days, times 4 for a family of 4, like my family that lives in Dedham, it ends up being $1,900 a month if they're charging $68 per day, $1,900 a week, excuse me, which I spend about $300 a week, and that is still a lot for me. So I don't know how any family could ever spend $1,900 a week for a family of 4 for food only. That's nothing else, just food. The second option that I did see somewhere else written down, $37 per person per day. That's a little bit less, but still outrageous. Comes out to $10.36 per week for a family of 4. So that's what's being done right now. I think it's abuse of the system, it's abuse of our tax money. These poor people in the hotel are not the only victims here. And a businessman who makes billions of dollars is using the system and doesn't care that we're also victims in the system here. They're taking money out of our paychecks. I know personally, I've worked extra shifts to make ends meet because everything is so expensive now, and I know people that live in the town that have actually gotten a second job. It's outrageous. We're getting killed in taxes. So that was my argument on that. But my argument to say for today is I think it's ridiculous to even have a second chance when your argument is sorry we did a crappy job filling out the paperwork. Sorry, now I'm going to pay for a lawyer. I was trying to save the money on that. I just think that's a terrible excuse. Thank you.
Okay, thank you. Drew, name and address for the record.
Thank you, Mr. Chair. Drew Popoli, 56 Green Lodge Street, Dedham. After the last hearing, it was very sad to hear that there was a lot of scuttlebutt about anyone who opposed this application was racist, xenophobic, intolerant, name the adjective. So I'm here tonight to tell you what the actual reason is for the majority of the opposition to this applicant. I want to be very clear that the majority of the opposition is not personally against the residents of the former Fairfield Inn. Many of us support the plight of wanting better for your family. The opposition is against the abuse of the system by some, and most importantly, against an organization, Giri Dedham, that is obscenely profiteering off the backs of Massachusetts taxpayers and is enabling a broken and abused right to shelter system. Giri Dedham is a business that provides zero benefit to our town, or really any of the towns that they do business in. And in reality, they do the complete opposite. By participating in the broken and abused system, they're adding to the various stresses we have as a town. Stresses on our public safety resources and stresses on our school system, which is in a very financially precarious situation. Giri Dedham is not here tonight, again, requesting a special permit to help the residents of this hotel. They are not here offering to help ease the burden of the operation on our town. They are not here for any other purpose other than to increase the scale, the scope, and most importantly, the profit of their migrant profiteering operation. Giri should be ashamed for the business they have gotten into. They should be ashamed for the conditions of their hotel, and we should not reward them for this activity or fiscal costs that they have imposed on our town by allowing them to increase their operations with this special permit. You are charged with determining, does the benefit outweigh the impact? And there is no way the impact is outweighed by the benefit of this application. Thank you.
Drew, anybody else? Sorry, David. I told her, you're next.
I agree with Mr. Popoli that Giri has never been a good neighbor.
Name and address.
Oh, I'm sorry, Elizabeth Doris Guston, 8 Walker Lane, Dedham, Mass.
Thank you.
I do agree with Mr. Popoli that Giri has never been a good neighbor. Their assessments have been way off, their taxes have been way down. They're the biggest crybaby in town. But that being said, there are still people that we need to feed. Not necessarily the town of Dedham, not necessarily the Commonwealth of Massachusetts, but we, as good people, they need to make 1,500 meals a day, not 3,000, so sorry. Give them another bite at the apple. Let Mr. Van Dam come back and do a good presentation. I was here for the last presentation, and those two guys were ridiculous. They had no clue as to what they were doing. So anyhow, if you could give them another bite of the apple, I think for the people that they need to feed. And none of us would want to be those people. Let's just do the right thing. Thank you.
Thank you. David, you're next.
How you doing? Dave Corsi, 11 Truman Road.
David?
The board member over in the corner, you said it all. Nothing's changed. It's a very simple vote. You voted no once. You came back. Nothing's changed in your application. It should be voted down again for the same exact reason. We can talk about the immigrants. We can talk about the hotel. But tonight was about the application. And you read everything on that application, and nothing's changed. And the vote should remain the same. No. Thank you.
Thank you, David. We'll take one more person from the public, if you'd like to be the last one.
Thank you. Mary Kay Petrie, Robinwood Road. I live right next to the hotel. I think everybody deserves a chance, yes, but Mr. Giri, he was on the news for giving the worst meals for all that money for one person per day. It was mush. It was cut up hot dogs with spaghetti. I think he's just trying to rake it all in, and I don't think he's going to be a good neighbor. You don't have to be a good neighbor if you want to have a business. But the town is not getting anything for this. We're not getting any money. We're paying a lot of taxes in the town. He doesn't care about the people. The people that live there, I have to say, they go over to Whole Foods, they get their food, they bring it back. They get their food delivery. They're not even going to eat this food, believe me. They don't like it. I see them all the time. They're getting food delivery Peapod. I just wanted to say that. Thank you.
Okay, thank you. Okay, we're going to close the public portion of the hearing now.
Oh, we didn't open it. It was just comment.
Well, this isn't a public hearing.
Right.
You don't need to close
So
it.
we're gonna have to
Open a
close it?
public hearing,
Okay.
close a public hearing.
All right, then we're not going to hear from any more from the audience, members of the board. Any more questions for the application, or?
Well, I only have one other comment, if I may, and I do agree that you shouldn't have a rebite of the apple, because if you open the floodgates, everybody would be coming about saying X, Y, Z, and W. That's why I say if somebody omits something, that's your problem, and you got to live with it. But the only thing that I say, that each case that we have that comes before us has to be analyzed on the merits of what is going on and taking place. And the only thing that I thought was this was the total grossest omission that I've ever seen, and I continue to support the idea that the information that they want to provide was not provided for the special permit application, and now they are prepared to present quote-unquote new information, which might be of substantive import for this board in making its final decision.
Thank you, Alan. All right, will of the board?
What do you think?
I'd like to make a motion.
Yep, I would suggest that if Norman is a proponent, he should make a motion to, what's that?
Alan.
Alan. Did I say Norman?
Yep.
You did.
That's
Sure.
I'm sorry, Alan.
Okay.
There is another board member of the board named Norman, just for the record, but Alan can make a motion, I think.
I would make a motion that we entertain, that they be allowed to resubmit the application. And I'm not saying what I would vote when it does come, but at least give them the opportunity to represent the application with a full application, which in my opinion would be a fair assessment of what the application is all about, and for the board then to have the ability to consider whether or not they submitted correct proofs of whether or not a special permit, the rationale had been approved.
Okay, so there's a motion. Is there a second on that motion?
I'll second it.
Okay. Roll call vote. Alan, how do you vote?
Yes.
Sarah, how do you vote?
Yes.
Tom, how do you vote?
No.
Greg, how do you vote?
No.
And the chair votes no. So,
And I think for the record, if there is a specific and mere material and change in conditions, which would, the members should state what they find that specific and material change in conditions to be, because we do have to reduce it into the record. So that would be Sarah or Alan, because.
Sure, I can speak to that. So in looking at the memo that they wrote, they included information on what the operation of Victory Bar and Grill was, which we did not have previously. So there was no comparison of what that was compared to what this potential detriment to the neighborhood would be.
Okay.
There is information about cars in and out for employees and how many deliveries, and they have an exact number. We did not have that information. We had to pull it out of them during the last hearing.
okay. That's it.
Alan wants to say anything else?
Oh, well, again, I'm just repeating myself. The new information is the information that was not provided to us. If you don't have any information and now you present information, it's a new information, which I think meets the criteria of that particular case that the council has cited. The only other thing I might make a suggestion, I don't know what the applicant's going to do, but I think for the purposes of the record, maybe their memorandum should be included in our record in case they decide to take an appeal.
Yes.
At least those comments that are making about the special permit and what the memorandum said would be sufficient ammunition for him to use in case he decided to take an appeal.
Yes, I would ask that it be part of the record, which I think it is by nature of its submission.
Submission.
So the vote's been 2 yes, 3 no.
Correct.
So what happens now? Nothing.
That
It's
you're
denied.
not in favor of it
So
moving forward, which pretty much ends the
ends the proceedings.
Well,
request.
Right.
I would
I
recommend.
think you still have to go to the planning board to preserve the appeal.
It's done.
I know.
Yeah, no, if we're going to submit an appeal, it has to be before that, which we'll likely do, to get that threshold, that gate opened, if you will.
But I would, so to get there requires both a favorable vote of the ZBA, that it is reheard, and the planning board, and not having one of those two.
Okay, so if that's in essence told, then sure, we'll go for the next board first before,
I
yeah.
think the statute says.
This is,
two
This is
boards.
it.
And then, but you asked for a second hearing.
no, if.
If you voted-
If you were
Right, right.
approved, then you
Then we
have to
go-
also get approval.
I understand.
From the planning board, but you were not approved.
So the appeal would be now, yes.
Yeah.
You agree with that, sir?
Well, any appeals of the decision of this is subject to
He helped me understand the.
Section 17.
Yes.
But I would recommend, just for full disclosure, that the board members that did not vote in favor at least articulate a reason why
Yeah,
for
sure.
the statute.
Yeah, yeah.
It doesn't have to be lengthy.
Nope, I don't believe that there are any material changes sufficient enough to change my mind. I knew it was a restaurant before, we discussed that at the last hearing. We discussed the meal count, we discussed the trucks in and out, we discussed the dumpsters. I don't feel that there's any material change that would change my mind.
Well, the board, I think it's the book, but in your findings, you said there wasn't any.
No, I think what was said at the time is that they were ill-prepared, but we did have discussion with them, how many meals would come in and out, how many vans did they think they would have, and that hasn't changed. So that's my.
I would recommend just state your thing and not have a retort. Yeah.
I pretty much agree with that. I don't believe there was any material change in your presentation, but I tell you, I thought you were pretty sharp and on point, and it's nice and refreshing to see a new face. But I'm sorry I couldn't support you.
Thank you.
Yeah. You can read my statement and what I previously said, because that's basically.
In the record.
You said your piece.
Yeah, okay. Where are we now?